cause number PD of 16422, Darren TRAMELL Hughes versus the State of Texas.
May it please the court. My name is Clint Morgan. I'm an assistant district attorney of Harris County, and I represent the state of Texas. The federal Constitution has two provisions that guarantee defendants some sort of right to be present in a courtroom. Both of these use, in court descriptions of them, the word confront. However, they are very distinct rights. The due process right to confront witnesses and be present, and the Sixth Amendment Confrontation Clause right to be present and confront witnesses. What happened in this case is the Court of Appeals confused those two. They used the test for when the due process right applied, and then they applied the Confrontation Clause. I'm going to ask this court to hold first. The Confrontation Clause does not apply at probation revocation hearings, consistent with all federal precedent on the subject. I'm going to ask this court to also hold that the due process right to be present requires at least an objection, or at least a showing of harm, but also an objection in order to be preserved for appeal, or else there's nothing for an appellate court to review.
Well, let me just interrupt you right there, because I think my understanding is that this defendant did speak up and try to be heard at the hearing. Is that sort of not sufficient to be a showing that he wanted to participate somehow?
He participated. What we need is a showing that he wanted to participate more than he did. He might have been fine on a Zoom hearing. Many people are fine on Zoom hearings. Oftentimes, criminal defendants don't want to leave their jail cells for a variety of reasons. And he may have just not wanted to come over. That happens a lot.
Wasn't there some discussion about the Zoom meeting was required because they thought he might test positive? So doesn't that kind of factor into what you just said about whether he wanted to leave his jail cell or his home or whatever?
He testified the jailers had told him he had tested positive, but he did not believe the jailers, so I don't know what the judge was supposed to do with his disbelief of that.
But is the problem really that it was a Zoom meeting, or that he was, like, cut off from communicating through the Zoom?
The problem they started raising on appeal was that it was a Zoom meeting, period, and now it's transformed into something of a couldn't talk to his right, couldn't confer with his counsel claim.
Wasn't he asked to mute?
He was, I believe, muted a couple of times, but he kept chiming in periodically, so he wasn't muted the entire time. We know that much. And when he had an opportunity to speak, what we've learned here is he testifies to a version of events that's actually not that dissimilar from what the state's witness testified to. And defense counsel's cross-examination of the state's witness shows he was aware of his client's version of events during this whole thing. And so when we get to the due process right to be present, we have to ask what else could he have added by being physically present that wasn't added by being virtually present.
Most of my work was appellate work before I came here, but I did get to play around in the trial courts from time to time, and I recall in my days as a prosecutor doing that kind of thing, that I would oftentimes see a client, a defendant in a case, lean over and whisper to his lawyer, and they would have some sort of communication about what was going on in the courtroom. And I'm just wondering, I mean, was there any guarantee that that kind of a thing was possible for this particular defendant? Did he have any avenue whereby he could communicate with his counsel and let his counsel know that, some thoughts that he might have about how his defense should be presented?
Well, the record is silent on that, as it's almost always silent when defendants communicate with their counsel privately. We know courts around the country used Zoom because it allowed private communication between individuals. We don't know in this case if he was able to do that. There was no objection, and so there was no ability to establish a record, and there was no indication that he wanted to communicate with his client more than this. That's why an objection in this sort of situation is so important, because we have to establish the facts of it. In my brief, I equate this to Linton, the insufficient translation service cases. If a defendant just claimed, I had a translator, but she wasn't good enough, this court would have no ability to assess that claim on appeal unless there had been an objection and a record about what could have been done. And this is sort of a similar concept here. If he needed better communication with his attorney, one of them needed to chime up and let people know.
Was there a waiver in this case with regard to, actual courtroom presence or Zoom?
he waived his right to confrontation as part of his original guilty plea. Now, there's no specific on-the-record waiver about this, but neither is there an objection. And when it comes to the due process right to be present, every other court in the country that I've looked at has required an objection in order to preserve this sort of claim, not an affirmative waiver.
But there has been great use of waivers also in the situation through COVID with choosing Zoom versus actual courtroom presence.
Sure, and I think most of those waivers deal with actual jury trials, when we were conducting misdemeanor trials via Zoom. I've not seen anything about that. That's outside the record is the best I can say to that. That might be the better practice, but that's not what occurred here.
Well, counsel, that's what I want to clarify. So is your position that really these rights, the due process right to be present, well, first of all, I guess I need to clarify that. Are you saying that there is no confrontation clause right present because he's waived it at the guilty plea, and there's also no due process right? Are you just saying there's no due process right because there was no objection? Are there any rights at all that I guess is what I'm asking.
I'm saying that a guilty plea waives your right to confrontation. That is a general rule, and it's a written fact of this case, that he waived his right to confrontation as relates to the charged offense.
So even if this had been in person, he couldn't have asked questions of the witnesses? He couldn't have confronted the witnesses against him? Is that really what you're saying?
No, the due process right to confront witnesses lets you ask questions. If there's a witness there, you get to ask them questions. But that's different than the confrontation clause right, which allows you to do things like exclude testimonial hearsay. The due process right does not allow you to do that. So, and it's also a different test for when it's violated. The due process right, you have to show actual harm as part of the error analysis, similar to Strickland, as opposed to the confrontation clause right, which is a procedural right that is either violated or not, and then we advance to a harm analysis.
So in an adjudication hearing, you have no right to object to hearsay or lack of confrontation?
You can object under the Texas rules of evidence. We get distracted in Texas because of how different our probation revocation procedures are from what's in the country writ large. And our sentencing procedures. The federal government, if you read Williams v. New York and the things that you get to consider at a federal sentencing hearing, it's a alternate universe from what goes on at a state court sentencing hearing in Texas, where we apply as a matter of state law the rules of evidence. And the rules of evidence as a matter of state law apply at a revocation hearing. But the federal confrontation right is waived by the guilty plea and does not apply to any sentencing procedures.
So let me ask you this, let me get back to this too, because you'd also mentioned the thing about trial. So this is what all you're really saying though is on this specific type of proceeding. You're not saying that there's no right to confront or there's no right to be present at like a trial or even a guilty plea. You're saying that once we've gotten to this stage for the adjudication and in a deferred adjudication where we're revoking probation, that's actually, there aren't any of those concerns, those rights, because they've already been waived.
The due process right remains. However, the confrontation clause right is gone. That evaporates with the guilty plea.
Is it gone for both the adjudication process and a deferred, or just strictly the revocation process?
It's gone for both. As a question of state law, there's a great deal of significance there. As a question of federal law, there is not. For instance, in a federal bench trial, for instance, when you plead guilty to the judge, he accepts your plea and then dismisses everybody for a while there's a sentencing report created, and you are not adjudged guilty until he assesses your sentence and enters judgment. But you do not have a confrontation right at the punishment proceedings of a federal trial because you've already pled guilty. There's no reason to cross-examine the witnesses against you because you have confessed to the crime.
And when the state goes forward, say for example, there's a new number one, they claim a new crime has been committed. Are you saying that the defendant has waived his right to confront that type of case against him in the motion to revoke proceeding strictly on his guilty plea?
Yes, because he's not being punished for the new offense. He's being punished for the crime to which he confessed guilt. This is adjudicating whether or not he committed the new offense is just determining how to handle the effect of his prior confession to this offense. That's why it would be permissible to, for instance, charge him also to adjudicate him and charge him separately with the new offense.
There has to be a
And-
finding of true or not true in order to go, for the state to go forward on it, right?
Sure, yes,
So-
yes, Your Honor. Just as there
So you
has
have
to.
to put on evidence to support that claim, and is it your position that a defendant does not have the right to confront those individuals who come in and say he committed offense X while he was on probation?
Not under the federal confrontation clause, no, Your Honor. The federal courts are unanimous that these sentencing procedures, simply there is no right to confrontation under the confrontation clause. And we're free to do as we see it under state law, and through the application of the rules of evidence, we've gone a long way. The gap between the federal confrontation clause and what we allow under the rule of evidence is not that large.
Has this court ever said before that there is no confrontation right at a sentencing hearing?
No, I'm not aware of it. I cited the case Rousseau where this court implicitly held there was one, but that was a death case. And in a death case, you are assessing new facts of the offense at the punishment phase. And so under Apprendi, you still have a right to a jury trial.
One of the reasons I think about that is because sometimes when a state gives you certain rights, the Supreme Court of the United States will say, well, you can't sort of give them this opportunity and then, like, for example, the right to appeal, right? They say, well, you can't give somebody the right to appeal and then say that they don't have a right to effective counsel on appeal, right? So, but we didn't have to give them a right to appeal to begin with, right? So, and here we give them a right to a sentencing hearing. Can Texas legitimately give somebody a right to a sentencing hearing and then say, oh, but you don't have any confrontation rights there? No, no, no.
If Texas gives you an additional right, we still have to fit that right within the federal constitutional structure. We may not, as the Supreme Court pointed out in Kansas v. Carr, experiment with the federal constitution. And so if we want to create a novel procedure, we are perfectly free to do that, and we have done that, and we extend enormous amounts of rights to these revocation hearings that would not occur in a federal court or in most of the courts of these states. What we may not do, what the courts of the state may not do, is extend the federal confrontation right to a procedure where the federal courts have agreed it does not apply.
Counsel, isn't there a distinction here between being on deferred adjudication versus being on what we would call straight probation?
For state law purposes, there's an enormous distinction. For federal purposes, no. Under the federal constitution, as soon as you plead guilty, there is nothing to do but go to sentencing. That was the case at the founding. That was the case up until today. Whether we choose to enter a judgment against you is just a question of how we are handling your conviction. And your conviction for federal purposes occurred at the time of the guilty plea. The sources are unanimous on that. Boykin, Blackston, that is simply how the federal constitution views a guilty plea. It is a conviction itself. And if we accept your conviction and we later decide to scrub the record for it, we are free to do that as a state. As a matter of state law, and that's what we do with deferred. And that's how we should view the deferred procedure. And he has all sorts of rights under state law, but the federal constitution does not reach down and apply novel rights that simply apply to novel Texas proceedings.
Counsel, but you mentioned the right to confront, and then it seems like you're going like, well, here's the right to confront, and you're treating it as a classic understanding of right to confront, but then you're talking about the history of pleadings and the history of the way that you go right to sentencing after a plea. But isn't there more to the right to be present that our founders would have understood at the time the right to confront was created? I mean, the right to be present under the confrontation clause, it was a little bit more broad than just simply saying I can ask questions. It was really to be there to have the judge sentencing you look on your pitiable state and possibly think, well, I should give the guy a break. I mean, just being present for sentencing.
Yes, and I believe that's encompassed within the due process right to be present, but not within the confrontation clause, because the key part of the confrontation clause is questioning your accusers. And at a guilt plea, there are no accusers. At the guilt stage, there are no accusers for the charged offense, or at least none worth questioning because you've already confessed to it or been convicted of it. And so that's Does that answer your question?
Sort of, but I mean, the concern that I have is that you're now saying, well, that's the due process concern, but the due process concern incorporates the historical understanding of the right to be present, and when I look at the history behind the right to be present, it is a waivable right. It is not something that can just be dismissed for lack of
I'm
objection.
going to suggest that when you look at the history of the right to be present, you're not dealing with Zoom proceedings, where somebody is virtually present.
No, but they are dealing with personal presence, and the requirement is personal presence. Regardless of Zoom, our founders, I don't believe for a second, would think, well, we should get a string and some tin cans and have somebody standing outside the courtroom and listen in. They wouldn't think that. That would still be not present.
Under under Maryland v. Craig, I think we do, in certain circumstances, yes, allow infringement. I'm over my, may I continue?
Please.
Thank you, Your Honor.
To piggyback
What?
off,
Excuse me,
let him
Judge,
finish.
he's still answering Judge Newell's question.
Yeah.
We do allow marginal infringements on these sorts of rights. And when you have a Zoom hearing, that's what this is. If you look at the things that are encompassed within personal presence, you can see the fact finder can see you. You can hear the fact finder can hear you.
And you can see the witnesses, and the witnesses can see you.
Yes.
And you
So-
have ready access to your counsel as well. under
Well, we know
Maryland.
at least we're certain that most of these applied in a Zoom hearing. That may have applied as well if the chat feature was on. We don't know if it was because there was no objection by anybody indicating there was any ability to communicate. And so that's a silent record on that subject.
Judge Walker had a question.
my question is, and I'm glad you said just what you did, because you're saying there was no objection at the time things happened, but wasn't there objection at the very beginning of this proceeding that the whole proceeding violated the confrontation clause?
I don't recall that. At the end of it, the defendant says something about how he objected to the hearing, but there's no he objected to a prior hearing, but we don't know what the basis for that was. Many people might object to being adjudicated for various reasons, some legal, some not. And there's nothing there, but there's also in this sort of case an opportunity to create a record showing error that was not apparent on the face of the record. He could have filed a motion for a new trial and created a record showing I was unable to communicate with my counsel. That was a right that he had and that was not exercised, and leaves us again with a silent record about whether he could communicate with his counsel.
And if
Did
he,
you want to
if-
reserve some of your time
I'm sorry.
for rebuttal?
if he objected at the beginning of the proceeding, does that change what you're talking about his failure to object later?
Absolutely. Had he not objected to this proceeding for any number of reasons, then we're in a completely different boat, because we're establishing a record about what happened and what didn't happen. We have an invocation of a right. We show that he did not want this, but I don't think that happened at the beginning of this hearing.
Okay,
Thank you, counsel.
May it please the court. My name is Pat McCann, and I'm here to represent Mr. Hughes. Mr. Hughes is here before this court on a deferred adjudication. That is a critical constitutional difference. I'm going to ask this court to, if it chooses to, go forward and say there is a confrontation right in a deferred. I don't believe the question of a general probation revocation is before this court because of both this case and the way this question is framed. However, at the end of that, I'm also going to hopefully tell you that you do not need to reach that deep a question on this. And I'll start here.
Can I just interrupt you real quick? I didn't want to cut into Mr. Morgan's limited time, but is there something that reflected in the record that when the defendant was muted, that he still had an ability to communicate with his lawyer?
There's nothing to reflect that he could communicate with his lawyer, and in fact, as a small bit of factual predicate here, and granted, we were all trying to do our best during the
Right, because the
pandemic.
Zoom has
Yeah.
finally raised its head, hit this level, right?
Here's the problem. The inmates who were brought into the Zoom hearings from the jail end have no pad or paper. They have no, if they're meeting you individually, the guards will ask you if he needs a pen, and you're allowed to pass things like that. Once the mute button is done, it's the equivalent of a gag. There is no means, other than jumping up and down, which, as they're often restrained, is a little impractical. There is no method to even signal that he wishes to speak to them.
But if a defendant is gagged in those types of situations, don't we typically look for that kind of argument? I mean, that doesn't sound like that was the argument that has been made is, well, this is a situation where he's voluntarily relinquished his right to be present because he's saying noisy things or he's being disruptive, and therefore he was gagged. And it doesn't seem like the arguments have gone down the shackling path that you're now positing.
I believe that they should, and as always, I am open to subsequent briefing if the court wishes. But I think here we have a fairly narrow question, and that question is, as my colleague has framed it, is there a due process or a confrontation right in a deferred? But he frames it, and this is the problem, he frames it as a probation revocation, and all of the federal case law that he brings to you is worthless on this point because we are in a unique procedure. Even in Betterment, which, by the way, I point the court to note 4 in my colleague's reply brief, because it specifically says that she limited that, Justice Ginsburg limited that decision to a speedy trial right in terms of sentencing, not confrontation. If you look at where we are, no one in federal jurisprudence has ruled on a deferred procedure. And this court has. This court has noted the differences between deferred and the fact that it is essentially a part of trial procedure. The client makes a bargain with the court. Give me a chance, and I will prove to you, in exchange for waiving a jury and going to you, I will prove that I am a worthy citizen who can abide by the law.
What are we supposed to do, though, about this silent record issue? Because, for example, like, we've had cases dealing with public trials, is an analogy that I would make. And in those situations, it is like structural error. The trial court is required to make findings in order to close the courtroom in some way. But then we've also had a case, at least one specific case, where the record wasn't sufficient to determine these things. So where does the burden lie? Where does the burden fall on this silent record versus, is it a situation, how do we determine where it should fall? Is it as simple as, or more complicated than, is this a waivable right? And if it's a waivable right, there's no evidence of a waiver, and therefore we don't care about the silent record. Or if it's a non-waivable right, then we do care about the silent record, and it's the burden of the defendant or the appellant to present a sufficient record. How do we answer that tension?
I would suggest this as a decision tree. If the court agrees with me that a confrontation right, because there is no finding of guilt so far, applies at a deferred adjudication proceeding, then it is a right that must be explicitly waived, and you do not have to consider harm. If the court agrees with my colleague's argument that this is a due process concern, where there is still a right under Scarpelli to be present, and a statutory right under Texas law, then a harm analysis should be required. In that case, if the record is insufficient, rather than say that this was improvidently granted, I would suggest abatement to the trial court for a certified hearing on the matter that took place, and directly consider it. This court has the power to do that.
That's like granting you an out-of-time motion for new trial, though. That's their whole point, is he should have done that with the motion for new trial if we abate.
It would be simply for a supplement to the appellate record. In other words, you abate it, go back, have a hearing on whether there was actually a denial, and then you can make a factual
But supplementing the
finding.
record is to correct a potential mistake in the record. That's not to add to the record.
I think, though, if the court is going to inquire if the record is sufficient, it has the power and perhaps the obligation to at least instruct the lower courts to make a sufficient record. And you could, as we would say, do the Heisman and take it to the 14th and say, 14th, you should have abated this and sent it back. You could do so now, since we've restored it to your jurisdiction. And then they could have a supplemented record, and then you might not have to hear this again ever. if it's a due process analysis. I would suggest in this that the issue is going to be dealt with whether it's here or on a writ of habeas, and that may also be why one doesn't need to reach the sweeping constitutional issues that are before this court now.
I have a question. I'm sorry to interrupt you if you had a thought you wanted to pursue, but some things are occurring to me, like when this court, during the pandemic, when we heard arguments, we broadcast it on YouTube and it was preserved there. Is this trial preserved on YouTube where it can be watched and we can, here's why I'm asking, because I'm wondering if you can give us some sense of the quality of things that this defendant seemed to want to be communicating whenever the judge decided that he needed to be muted. Was it pure craziness, or was it, that's not right, kind of thing?
From personal experience, I can say it runs a gamut of these things. On this end, the pure craziness, and on this end, the detective is lying because I was in another place and there's video camera on it.
Okay.
And that is the problem with this. To answer your short question, no. As far as I know, those hearings are not preserved in any way that's accessible to us.
What's on the record regarding what he was told in the jail about how he was going to present his case or defend his case? Is there anything that shows he was told, too bad, you're not going to court, you got to do this because we think you're...
As far as the COVID test, Your Honor, the problem is that the entire matter is essentially third-party hearsay. And to be fair, there was constant testing of people in the tanks. But if anyone tested positive, not just this individual, in his tank, he would be isolated and quarantined under the conditions that were there at that time. And there is, to my knowledge, there is no record because the tests were going so quickly at that time that they would do a test and then a follow-up and then make a note if there was a second positive.
Is there someone in charge of the mute button besides the defendant?
The judge, Your Honor,
Okay.
is in charge of the mute button. And for technologically challenged judges, the
Is there such
court
a thing?
coordinator,
I think he's
the
saying
coordinator
yes.
would handle the hosting. And he or she would have control of the mute button. And in reference to that, Your Honor, I can only hope that my colleagues on my side get up to a reasonable level of technical competence, because I'm afraid that's coming on the bar too, as far as that goes. But if we go back to the constitutional arguments here, I think my colleague's point is well taken, that deferred is a unique procedure. It's a procedure that the legislature created and crafted, and as recently as the last few years tried to amend to allow for DWI deferreds. And I think Representative Dutton in 2009 tried to bring in a modification so that licensing boards couldn't consider deferreds. We have the pardon in the Constitution about deferreds that's available for people to successfully complete them. So it's a huge difference.
You spent a lot of time, counsel, explaining why deferred is different, though. But there's a lot of federal case law dealing with federal probation issues. And so and that's what the state is arguing. What about that? What about the fact that in the federal proceedings, there doesn't seem to be a recognition of some sort of constitutional right?
Well, I would respectfully suggest that my colleague's argument is wrong for several reasons. One is we go through the things that he's brought. Supervised release, no analogy in Texas
Why?
procedure
What is
at
that?
all. Supervised release, and having handled federal clients, it's simply a congressionally created, judicially supervised parole-like procedure. There isn't a judicial department, probation department, that helps the judge do this. But the judge directly supervises people for terms of 1 to 10 years or sometimes life after they've completed their actual sentence. So no analogy to Texas procedure whatsoever. The second is parole, and I think we're all clear that for the limited purposes in United States parole decisions, which are confined mostly these days to the DC Circuit, parole is not a trial or a trial procedure. And as my colleague points out, one is on conditional liberty. And so only due process rights apply there. So I concede that if this were a parole case, that would be true. Probation in federal decisions is not analogous to our deferreds. Taylor, Shivers points that out. They go into great length about it, as you have no doubt reviewed for this, and the issue
They still use it in the
is,
sentencing guidelines, don't they?
I'm sorry?
They still use a deferred in the sentencing guidelines, don't they, in the federal system?
The federal system does consider that, but it's part of the regulatory compliance on the PSRs, the pre-sentence
It adds
reports.
to the points that eventually
It
enhance your
can,
sentence.
it depends on what the nature of the crime is, and they go through a different stage on each of those, and one is able to argue that, for instance, this was not a case that is as bad as it sounds, because deferreds were a type of analogous community supervision.
But Mr. McCann, isn't he arguing that federal sentencing is the same as a deferred adjudication hearing because they've had, the guy's already entered his guilty plea and he's gonna come back for sentencing? How do you respond to that argument?
I would say if that is the argument, then it's incorrect for these reasons. First, that the deferred by its nature in adjudication proceeding includes a judgment of guilt. For instance, as you recall, you could keep someone on deferred, modify their conditions. One could put them on probation, straight probation, to give them another chance. That's still an option that many people follow. Or one could adjudicate them guilty and then proceed to a separate sentencing procedure. Our own code recognizes that the sentencing is different. It's a separate procedure from the adjudication. And that, I think, is a critical difference for your analysis, because when you're looking at the functions that happen in there, the judge has utter discretion, but that was traded before the trial actually commenced, so that the person has a chance to be diverted. Now, my colleague's point about, deferred has been changed and has evolved over the years is fair, but it's still the best deal short of a pretrial intervention that one can get for a client. And the liberty, interests, and restraints are markedly different on deferred. One can still get them sealed or non-disclosed under the code. One can get a pardon for them that a probation does not necessarily offer because it's actually in the Constitution. Yes, sir.
No, I'm sorry, I'm just.
Oh, I'm sorry. But I also want to point out that in all of my colleagues' case law, the difficulty has been that so many of them are both factually different and also they're focusing on different rights. And for instance, in the reply brief, we're talking about speedy trial between federal conviction in a jury trial and sentencing. And I think the elapsed time was 14 months. Justice Ginsburg took pains to note that she was only talking about speedy trial rights, nothing else, and actually refers us back to Memphis v. Ray. So we're still in that situation. And I believe that there is, while Texas's deferred procedure is unique, it is certainly not violative of any constitutional right. We're simply taking a path on a trial procedure. And if the path goes badly, as it did for Mr. Hughes, then there are remedies for that. But at the same time, he's going to be judged guilty. And that's a critical difference. And I believe the confrontation must apply in that instance. And taking this back a bit,
But on that
there is
issue,
no-
he's not
oh,
really,
sorry.
but that's what I'm saying, like, on that issue with deferred, he's not he's not really going to be able to contest his guilt. He's not really going to be able to question witnesses on his guilt. He's not going to be able to undo the finding of guilt. He's already confessed.
Respectfully, he could, for instance, fire his counsel, and that's another right that was, obscured by the mute button, and represent himself. I'm not saying that's going to go well. I'm simply saying that that's a right that is still here for us. He could have provided information to the counsel that could have resulted in more probing cross or some other issue that could have mattered.
And the
We don't know.
judge- And the judge, as the sole fact finder, can do whatever he wants within the range of punishment.
Yes, yes. And I think that's a power that being granted there means that you also have to,
I'm sorry if I wasn't clear, and I was just really specifically referring to the guilt aspect of a deferred adjudication proceeding. Obviously, there's a sentencing portion to it as well.
Okay.
But as far as the guilt portion, I guess I was looking for, and you did answer that, what are some ways in which his presence would be critical to that part of the deferred? And while it seems like it's admittedly low, you pointed to a few other things, but that doesn't change the fact that he still has the ability to question witnesses with regard to his punishment or things like that.
he does, Your Honor. And this also, and getting down to 2 minutes, so I'll try and answer yours more fully as well. The judge's discretion, to me, is an added reason to treat it as a pretrial matter or a trial matter, because this is not, perhaps the right word is, although it may be treated as a quick and easy thing, judges, as you know, can sentence people within the full range of that matter, and the confrontation right becomes all the more important because you have not bargained for a limitation on your potential sentence. And that is huge. And in fact, in federal law, one of the principal reasons that one can withdraw a plea under Rule 32, and I believe the case is Bradshaw v. Stumpf, 545 U.S. 175. It talks about the ability to withdraw a plea and what factors one has to look at. And those have been, if not codified, adopted for federal Rule 32 proceedings to withdraw a plea before sentencing. So there is still a method for the federal authorities to have a plea taken back or have that withdrawal granted. And that means that simply pleading is not enough. Yes, sir.
I am actually raising my hand this time. Mr. Morgan argued that this is a Zoom meeting and we don't know whether there was a chat function that he could have been communicating with his client over that. I mean, the lawyer and the client could have been communicating that way. Well, what I wonder about that is how much of that can we sort of take, if any, can we take judicial notice of, that there's this program called Zoom and everybody knows it has a chat function and any person, can use it even if they're in jail and maybe not educated. I mean, would we presume that somebody taught him how to use this program? I mean, do you have any response to that?
I do. Nothing could be assumed on this, particularly since, and again, this goes back to Judge Keel's notion about technical competence. Learning Zoom was a process for all of us to do, and for a person brought in shackles for a hearing, not given a pen, they are not given a manual instruction. There is a bailiff who comes over and says, hit this. And having all of that communication, as far away as it is, go through the filter of the background noise of the court, and even if one could get a chat established with your lawyer, unlike the ability to sit there, simply grab Mr. Morgan in presence.
And say that cop is lying.
Yeah. Quite frankly, a lot of the lawyers are not aware that they're being chatted with. Those limitations come into play every day in the Harris County Jail. And I wish they didn't, but they do. The last thing I wanted to leave this court with is I ask it to narrow its focus here. If it wishes to, of course, it can proceed to the constitutional questions. But I believe that if one looks at this matter, first off, this is not the right vehicle for deciding if probation revocations should be considered under a due process standard, I believe. Thus, the argument that this is an apple compared to an orange. If one determines that there isn't a sufficient record, I believe that giving this to the 14th with suggestions for developing such a record would be appropriate. I don't believe this court has to answer my colleague's deep question on this to get this case resolved, because at the end of the day, there was one presumes a credible witness in front of the judge. Even if he got all the things done over, this result may or may not be the same. But it's simple enough to do, in the sense that nobody's gone, there's no loss of records except, of course, for the Zoom. And this should be a fairly straightforward proceeding for the state and the court to redo. And I will leave with, and I realize I'm past time now, but the trial court could have done this differently. And if a best practices suggestion would be helpful, certainly postponement of this that day, and I recognize everyone has a busy docket, would have been a solution that would have made sense and perhaps allowed communication. And perhaps if there was indeed a COVID scare, which we don't know, that would have allowed time for that to have been alleviated. And it seems as if it's important for this court to give guidance on that as well, simply because, unfortunately, we are neither out of COVID, nor are we, I hope, never going to deal with another situation of communicable disease inside a prison. And with that, I would ask that the court deny the state's PDR and that it grant the lower court's decision authority.
Thank you, counsel.
Thank you.
So I'd like to stress 2 points on
Could I
rebuttal.
ask you something so I don't have to butt in on you in a minute?
Sure.
Do you know if there's any record evidence as to whether or not the defense attorney knew who was muting him, who was muting the defendant?
No, I don't believe there's, the judge says mute him as though the judge is telling someone else to do it and not doing it himself, but we don't know who's doing that. Or do we know if anybody in the room knew who was doing it? Presumably somebody knew, but that's not in the record.
Yeah, there's nothing to tell us that the defense attorney knew.
Correct.
That his client's being muted at this point.
Well, we know the judge is saying mute, but then later he's unmuted, and so the record there is a little hazy, but there's nothing specific on that subject. So.
Okay, thank you.
So as to what can we take judicial notice of about here, Zoom, I think that's not the correct question. The correct question is, has the appellant produced a record showing reversible error? That's their question on appeal. So for instance, if we go back to Garcia, the translator case, that was preserved via a motion for new trial. If Garcia had just appealed and said, my translator wasn't translating, that would have been a completely silent record on the subject, and this court would have had no way to resolve that. If this client could not communicate with his attorney could not communicate with him, there was some obligation on their part to make a record of that, and they failed to do so. So at a basic level, they have failed to produce a record showing reversible error on that subject. My second
The
point
question is how do either the parties, the defendant or the defense lawyer, know that somebody's being muted if it's all done behind the scenes?
well, the judge is saying mute him.
Right.
And on Zoom, there's normally a little...
There's a little red
Yes,
thing
there's
that says mute.
There's
next
some
to his
indication like
picture.
that. Right, but
Okay.
the judge is saying mute him. So we know that for whatever time he was muted, there was some notice that muting had occurred. I
But then
guess
he was unmuted without the judge saying so? So
That's-
there's signals going on that are not reflected in the record?
that appears to be the case. That appears to be the case. Like, I would almost take the position that we don't know he was ever muted, but there are 2 instances where he's cut off mid-sentence. I'm not going to fight that that's muting him, but some people do also stop talking mid-sentence. I don't know what's going on there. The record is silent. Again, he's just failed to produce a record showing reversible error. And the second point I'd like to make, if we're going to make a dividing line here that deferred is now about the question of guilt, the elephant in the room is, why doesn't he get a jury trial? There are other rights in the Sixth Amendment that come in to protect you from a finding of guilt. One of them is confrontation, but the bigger one is a right to jury. And nobody has ever applied that to any procedure that looks vaguely like this. And so if this court wanted to go that way and say the confrontation clause applies at a deferred because it's about the question of guilt and we have some sort of residual presumption of innocence, I simply don't know how you refrain from giving him a right to a jury trial at that point in time.
Well, what about the fact that it's not just about guilt, it's about the range of punishment as well?
If it's about the range of punishment, there is no confrontation clause right under the federal Constitution. And so, just as there's no jury right under the federal Constitution for that sort of question.
I don't think I pressed Mr. McCann as hard as I wish to on this question, but is there a YouTube, someplace where we can watch what happened as opposed to reading a cold reporter's record?
I'm not aware of any. This is, the trial courts don't typically preserve their stuff on a YouTube channel. There's a sort of an internal Harris County network for watching these sorts of things. It's not as widely disseminated and recorded like YouTube.
They're not influencers.
No, very low follower counts. If your honors have no further questions, I thank you for your time.
Thank you, counsel. The case is submitted.